story. Want to just introduce by saying I see a lot of new faces, a lot of new people joining this. And if you want to be directly on the email list for these series and you're not on it already, or you heard about it through social media or through somebody else, and you wanted to be part of that email list, please feel free to put your email address in the chat or send an email directly to dana@danagoldman.net, and you will be included in those notifications for upcoming workshops. Okay, so without further ado, want to introduce our wonderful panel here. It's really a great honor and a pleasure to have such an esteemed panel this evening. Our Honorable State Senator Jason Pizzo, who really needs no great introduction in the sense that he's not only a person who represents our SD 38 and our district, but of course, he is really at the forefront of dealing with condo rights issues and leading the charge for condo reform. So that's why it's such a great opportunity to get his thoughts and his perspective, because he's an attorney. He talks the talk, he walks the walk, he understands our issues, our problems, and our challenges. And he really is, again, leading the fight for condo reform. So thank you very, very much, Jason, for being part of this, this workshop and this discussion. And then, Jason, if you want to do the introduction of our greatest new addition to the overall team of high-rise and condos in South Florida, Spencer Hennings, go ahead and make the introduction.
So I don't know if you have a formal bio that you want to follow up on, but I just want to impress upon everybody the rising star and rising responsibility, and probably a bit of a cathartic messiah for many of you who have struggled for years, and that's Spencer Hennings. He's the sharp-looking dude with, I don't know, 5% body fat and no wear and tear on him yet. Let me explain what Spencer's position is. For many years, the Department of Banking Professional Regulation, regulating condominiums, timeshares, and other things, has had the position of an ombudsman who's supposed basically like sort of an overseer, if you will. But kind of quixotically, that ombudsman was headquartered and stationed in Leon County here in Tallahassee. I think there are 2 condos in the whole county, in Leon County. We have a few more down by us. So we've sort of pushed and pressed. Many of you recall Secretary Halsey Beshears, that came down to Aventura. Mayor Wiseman was gracious enough to host us there, and many of you attended. I know Eli came down from Boca and places far south. And Secretary Beshears listened to a lot of the issues that people were suffering from and continue to struggle with. And so one of the big initiatives was actually to bring Spencer's position down to us. So he split this time right now between Fort Lauderdale and the city of Sunny Isles Beach has been gracious enough, and it's blissfully self-serving to open up their doors as well. I think at City Hall with some space to make them available. What is missing is the ombudsman position needs some more teeth. So what we all agreed on was Spencer was going to spend about a year. We met early, I think at like a Panera Bread somewhere in a midway point when Maggie and I were on the road somewhere else. And I said, listen, I'm sure you have some initial feelings and some inclinations, some immediate impressions. Give it some time. You'll see how bad it really is. We're going to give you a heads up and some leads on some places to start, and we're going to info dump a bunch of emails and correspondence. So some of your text messages and emails that all of you have sent me over the course of the past year and a half or so, Spencer has absorbed, and he's really taken off. And I can tell you, based on a lot of his frustrated phone calls to me, that he's a little pissed. And so what we're going to do is work to get him real teeth and enforcement and sort of shore up the gaps. He's seen a lot of elections and a lot of fuzzy math and mismanagement. So I know that he's amped up and excited. I would like to take this opportunity, if I may. Secretary Beshears was always very accessible to us, always very professional, works and served at the pleasure of the governor. He's recently, he went through a bout of real sickness and has stepped down from the position. And so we got right on the phone even before he resigned with CJ Aulette, his replacement, who sounds very enthusiastic, wants to hit the ground running, and seems to have a hankering for going after fraud and trying to right some wrongs as well. So Spencer, guys, Spencer's going to become a very, 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 very important and influential position, purpose, and the ethos and the mindset is there to really tackle these issues. So Spencer, welcome.
Thank you so much for that introduction, Senator. Working with you has been absolutely amazing. Since my appointment in July, I've really looked to you for guidance as I've been reinventing this office, and I'm looking forward to continue to do so. And I also really appreciate the words about Secretary Bashir's. I'm very close with him, and he was really a champion behind bringing this position to South Florida and creating a lot of new policies that are going to help condo owners in the future. So, I'm excited about the future. I think the division is looking good. It's going to be a lot more helpful in the future than it has been in the past. And I'm looking forward to this webinar as well. So thanks again.
Okay, thank you so much. And again, it's been wonderful collaborating with you thus far, and we're looking forward to a very fruitful, very productive, very incredible relationship, and really, you know, for the betterment of our whole community. Everybody can mute other than the panelists. That would be great because there's a lot of static here. So if you could help out, if you could just mute, or I'll try to do it on my own, but it's just, I'm hearing a lot of back noise. Robert Yaffe, my friend, my colleague, who's been with me since the beginning on these condo rights workshops. He's a board certified attorney. He represents both associations and unit owners, and he's of a very similar mindset. So Bob, if you want to talk for a second, and but you really, you've been a fixture in the scene, so to speak. So thank you so much for joining our current workshop. Go ahead.
Thank you, Dana. And Spencer and Senator, it's good to see you both here. Spencer has been very helpful and accessible to to the condominium and homeowners association community, unit owners, attorneys, and so forth. So you are a great addition, as the Senator said. And Senator, it's good to see you again. And as Dana said, you've been a great advocate for the rights of condominium owners and reform of the condominium law. So look forward to the next upcoming session starting in March, and making some more progress. And as Dana said, I represent primarily unit associations, but I also represent unit owners. So, this is a great topic because I see the difficulties associations and unit owners encounter, from both sides. So, I look forward, this should be a very productive workshop.
Terrific. Thanks all. And again, I'm Dana Goldman. In case anybody doesn't know me here, I'm a commissioner in the city of Sunny Isles Beach. I'm also a practicing attorney, and I live, breathe condo stuff. So that's how I come to this particular topic. Okay, so our topic today is Holy Grail or Horror Story. And I'm going to take a small straw poll with Spencer, Jason, and Bob Yaffe. Are official records the Holy Grail? Why are they so important? Who wants to start?
I'll start. Unit owners have very few rights in condo associations. Aside from electing the board, they don't really get to control how the association is run. So being able to have a transparent association and the unit owners having the right to get in there and see where's the money coming, where's the money going, how is the association being run, that is of utmost importance, because without that, there's no transparency. You don't know where the money's going. You don't know how the association is being run. So it keeps the board in check, and it makes sure that everyone can see what is going on in their association, which I believe is absolutely essential.
Absolutely. It's all about transparency. Bob, would you agree?
Absolutely. It's one of the most important rights that condominium unit owners have.
Jason, I'm sure you have a thought about that, having been in the battlefield for this period of time.
Yeah, I remind people that, years ago, your idea of a home was something that was single family and detached somewhere. And then when you get to a condo, it's really just a question of how much of your rights and how much of of your control of your own destiny you're giving up.
Okay.
Dana, can we just ask everybody to mute and then we'll unmute the people that are talking?
Yeah, I'm working to mute everybody, or just you want me to
Commissioner,
mute?
Commissioner, there is a mute all button on participants, and then if you hit that, everybody's muted, and then you can unmute the speakers one by one.
Okay,
Mute,
perfect. I'll
so
take
go
care of that.
under participant, and there is a mute all.
I'll take care of that right now. Okay, here we go. Okay, better. Okay, next part of our straw poll. Do you have your own horror story? How many horror stories do you have? Can you quantify that?
I have an unlimited amount of horror stories. That record requests are one of the big ticket items that I deal with every single day. And I'm on the phone with associations and board presidents and attorneys and managers literally every day working out record request issues.
Jason.
I would have to say, I mean, we've had some funny and some anecdotal stories. I showed up one time to a condo and the manager pretended not to know what a state senator was or what I was doing there or any of that. And then by the time that I was done saying, just let me in the meeting and let me go see these particular people, whatever. At the end, she's like, oh, by the way, I'm the niece of your opponent. So she knew exactly who I was and why I was there, which was pretty interesting. The first time to Norma's place was great. No, but we've gone into a lot of your units and a lot of your buildings. But the horror story for me really is the bullying and the predatory behavior of a lot of places, and unfortunate for a lot of the wrongdoers that we're going to see shortly. Those that like to bully are going to meet their match from somebody who used to handle shootings and homicides. So I don't take very kindly to bullies. The Lepsettos should have their own TV show or write their own novel about what they've seen up at the Boca View condo.
Ah, the Boca View, that's interesting. I just read a few cases in the last couple of days about that particular project. Okay, straw poll. Do we need to reform the official records inspection laws and why? Jason?
For me, it's more about access. I think Spencer can speak to it. We've spoken about it at length. There really is in this day and age, if private enterprises are putting satellites up in orbit, at the drop of a hat, we should be able to see the records. A lot of the animosity, the back and forth, the continuing acrimonious relationships between management and some cabals of associations that push back against people that are just asking to fulfill simple requests. I think we can obviate a lot of those issues and a lot of the interaction, a lot of the face-to-face and the back and forth and interpretation by making things more accessible and available digitally. That's really my position.
Okay. Bob, can you go through a little bit of what are some of the official records of the association and what's considered official records and what's not considered or what's considered inaccessible?
Sure. So we practitioners and all of you out there, we have condominiums, cooperatives, and homeowners associations, all governed by different chapters of the Florida statutes. And each of those 3 chapters has an official records section, which identifies and lists all the official records of the associations. They're very similar, but they're not the same. There are some differences. I think that the condominium section is the most substantial. But the records are what you would typically think, a copy of the original plans of the association, the recorded declaration and other governing records of the association, articles of incorporation, bylaws, current rules, minutes of the meetings. You would think that associations would be pretty good on keeping those minutes, a roster of the unit owners identifications, such as, their official mailing address, voting certifications, current insurance policies, copy of any management agreement or other contracts of which the association is a party, detailed financial records, of course, audits, contracts for work to be performed, bids, ballots, records of associations. And there are some, catch-alls, all other written records of the association. Most of these records have to be kept for 7 years. But certain records, particularly the minutes of meetings, the governing documents, rosters of unit owners, and well, not rosters, but books and records that contain the minutes, have to be kept permanently from the inception of the association. I mean, some of our associations in Florida are now 50, 60 years old at this point in time. So, they are required to maintain all those records. That was a recent change, I believe, in the last couple of years, requiring permanency of certain records. And not all of the chapters have the same requirements. Exceptions from records are records that are privileged that really shouldn't be seen by everybody. For example, medical records of unit owners. You have cases where a unit owner may ask for a reasonable accommodation from the association. They may need an emotional support animal, for example, and they submit a letter from their doctor. Social security numbers, financial records of unit owners when they're applying to become a unit owner. They submit applications, they've got all the financial information, background checks, and so forth. Those records are not accessible to all unit owners. Attorney-client privileged records. A lot of associations, of course, are involved from time to time in litigation, and records regarding that litigation is privileged. I mean, you certainly don't want, an association doesn't want its adversary to have access to the thought process of its attorney who's representing it, in whether in defending or prosecuting an action and so forth. So those records are not available. And that's the general set of documents that all associations are required to maintain.
Okay. Can the association limit the number of requests that a unit owner has per month, per week, per year? What sort of limitations are there on official records inspections?
So the condominium or homeowners associations, condo associations have the right to make reasonable rules and regulations governing access to records. But those regulations, unfortunately, sometimes are by the associations, intended to hinder access to records. I've looked at a lot of arbitration decisions, administrative decisions. I've seen circumstances where an association will say, well, you get to make one request per month. You can come in a total of 8 hours per month. You can't see the same records twice. If you're in litigation, you should get them through the court system and not through an official records request and so forth. And the arbitrators who have issued these decisions have basically said, no, you really can't do any of those restrictions. Access means access. Even unit owners who sometimes may abuse the process by doing serial records requests are entitled to make those requests. So a reasonable regulation might be, limiting a unit owner's request to 3, 4, 5 times per month. Some of the arbitration decisions have said that, maybe, Mondays, Wednesdays, and Fridays, or a certain number of hours per day. But other than that, associations have to make the records available. And the excuse that, well, you're getting it through the lawsuit is not a valid defense to failure to produce records. A unit owner who's suing an association can go both tracks. The attorney can ask for records through our civil court system, and the unit owner can ask for records through a records request. So it's really a test of reasonableness and whether the association is trying to hinder access to records.
That's absolutely right. It's really about reasonableness. So things like location, duration, so on and so forth. We have some ground rules, right, Spencer? We have a ground rule of it's got to happen within 10 days. But other than that, there's some latitude that the association has, right, in terms of what they produce, how they produce it, what form they produce it, whether it's going to be in 55 boxes, banker boxes on the bottom of the basement 40 miles away or not, right? As long as they get the response within 10 days, right?
You're absolutely right. And I think the entire system is antiquated. And I also think it's unfair to expect a unit owner to, be given access by letting them in the records closet with 50 boxes from the beginning of time and expect them in a couple hours to be able to go through and conduct an audit, essentially. especially if we're talking about an elderly person here, I think it's ridiculous to expect that, and I think the entire system is antiquated.
Okay, we're gonna absolutely get into that. But first, I'm gonna do some rapid fire hypos, and then this is for Bob as well. But everybody feel free to join in, and then we're gonna get into the policy aspects, the implications, website, and reform. So here we go. Bob, what rights do renters have to inspect official records? Should renters have inspection rights? Are the rights that they have adequate?
Renters' rights are limited to requesting a review of the governing documents of the association, the bylaws, the rules, regulations, declaration of condominium, and that's essentially it. They're not unit owners, their access is limited.
Correct. Question is, should they have more? Not sure how you feel about that, but they do have a very limited right, and that was just of recent origin, correct, in the Condo Act?
I believe so. I mean, in my personal opinion, listen, the declaration is a contract between the unit owner and the association, and that establishes the rights and remedies of both parties, as well as the Condominium Act and the governing documents. So, the tenant is a temporary occupant, presumably, and is not a party to that contract. I don't really have an issue limiting access to renters.
Well, they need to know what the rules are, but
right, of course.
Right, because they have possession of the property. Okay. Next, rapid fire. The unit owners want to know how much the property manager makes, his salary and benefits. He's in-house. Official records. We pay for his salary.
Well, certain personnel records are shielded from disclosure. Unit owners don't have access, but unit owners are certainly entitled to a copy of the management agreement. And the management agreement would typically, set forth the compensation of the manager, whether it's an in-house manager or, Miami Management or any of the other larger management firms for service and so forth.
Well, when I in the past requested the management agreement for the employment agreement for a manager in my condominium association, I'm sorry. Somebody's some static. We're going to get to the chats in a little bit. They redacted the portion of the compensation. Fair or unfair?
Well, you're not entitled to see somebody's social security numbers and things like that, but the terms of the contract are available to you. Or should be available to you. I don't see any reason that should be redacted.
Okay.
I mean, it's your money as a unit owner. You're entitled to know: are you spending $100,000 a year on a management firm, or $20,000? How many employees is the management company bringing in? A lot of times they're not association employees, or the management firm's employees.
Okay. Going to the office to inspect records, or worse yet, the attorney's office, is very challenging. It's downright intimidating. Can I hire somebody to do this for me?
The unit owner can designate a representative. I've been designated as, unit owner clients representatives to inspect records. So yeah, I mean, you can designate a friend or another family member. So yes, you can.
Absolutely. You can have an authorized representative, as long as you authorize that representative, they can do that for you. One of the unit owners requested an inspection of the records. The unit owner wanted her neighbor to accompany her, but the association flat out refused. The neighbor wanted to help. Reasonable?
I don't know that that's a reasonable restriction. A neighbor, another unit owner, coming in to help go through records, I think that's fine. The only restriction, these days, I limit record inspections. You've got to wear a mask. I don't want a lot of people in my office, but otherwise, I don't see that it's unreasonable for a unit owner to bring in a neighbor to assist.
I think there's precedent actually for prohibiting that. There have been law firms that have actually said, no, you can inspect, or your representative can inspect, but your neighbor can't come accompany you. Should the request for an official records inspection always be made by certified mail?
Well, the purpose of doing it by certified mail, or perhaps hand delivery and getting a dated receipt, is so that if there is a violation of the records access, You can demonstrate, I gave it in on January 21st, and 10 working days later, I don't have my records, and you may file a complaint with the division or an arbitration petition or with the Bureau of Compliance. So you need to be able to demonstrate when you made your records request. That's helpful, but there's no requirement in the law that you send it by certified.
I think that's exactly right. You want to preserve your rights, right? Best practice from a unit owner standpoint, Spencer?
Yep. Absolutely best practice. This is what I recommend every day. Certified mail, return receipt requested. That way you can prove exactly when they received it. There's no questions, there's no argument. And furthermore, I believe in 718, when we're talking about subpoenaing records, which we can talk about later more in detail, there is language in there about having to give the division those copies of the certified letter or the return receipt. So without that, you might not even be able to get the division to subpoena those records if the association doesn't comply in the first place.
That's exactly the thought on that. Really, to preserve your rights, should you have any challenges moving forward. The association, and more specifically the board, hired a private investigator to surveil or at least dig into some of the unit owner's personal business. I'm one of those unit owners. How can I obtain a copy of that report? Official record?
If it concerns you, I would think so. Otherwise, I mean, there may be confident, maybe Spencer has some more insight on that than I do, but it's about you. I don't see why you shouldn't be able to have it.
Okay. The association paid for it, right? It's an official record. Spencer, you have a thought?
I'm sorry, what was the question on that? I missed it.
Private investigator, association or the board hires a private investigator and has a report on a unit owner. Official record?
That's interesting. I think there's a good argument that it could be. There is a catch-all in 718.111 saying that everything that's not specifically disallowed is part of the association records that is entitled to be inspected. But then, we do have some things that Bob had mentioned before about like social security numbers and information gathered in connection with approving a lease or sale. So I'm not sure at that specific situation if there's even maybe perhaps an arbitration case about that. I don't know both ways on that.
Okay. I'm going to unmute you. Okay. I want the documents to be delivered to me. I don't have time to pick them up. Reasonable?
You're still muted, Bob.
Sorry. There's no requirement that they be delivered to a unit owner. The requirement is that they be made accessible to the unit owner. In the statute says, they can be made accessible, I think, within 45 miles of the location of the association or within the county in which the condominium property is located within 10 working days. So, some associations are more accommodating than others, particularly during these times. You can request copies. Some associations will, have a lot of the larger associations have a lot of the records on their website, if they have a website. I had a situation recently where I was asking for records on behalf of a client, and they invited me to come to their office, and I said, listen, would you mind just PDFing them and sending them to me? And they did. So it really depends on how accommodating they want to be.
Very true. Okay. I've asked for all of the email correspondence between the board members and the property manager and amongst the board members prior to the board meetings over a 1-year period. Are these official records?
Well, I think, that's it. I think a little bit of a difficult question, which maybe Spencer can help with. When board members are emailing from their private computers, at the Condo Institute, that's held every year up in Boca, they've talked about unit owner, or rather, board member emails. And I think there are distinctions, as to whether it's an association email account or an association computer or a private computer. But along those lines, maybe Spencer, you could address also, a lot of associations have an email address, or maybe the manager has the email address.
Right.
Oh, you got muted.
I'm sorry. Go ahead. Go ahead.
Oh, I think I got muted
Yeah,
again
there-
also. Sorry.
Okay.
Association muted Bob.
Right. So what I was asking is, the associations themselves may have an email address, or it might be through their management company. And a lot of confidential information may come in, applications to purchase, medical records for, accommodations and so forth. And I've seen associations where, all the board members say, well, I want the password and I want to be able to access that email account from my own computer. And, they don't want to just leave it to the manager or a designated individual. So a question along those lines in terms of access to, emails, should all board members have access to an association email account and be able to, communicate that way?
So we've
Yeah.
talked about that. So we'll get, Spencer, there's some precedent for the fact that if the email is on the board's server or the board's, if it's a board member and it's their personal computer and it's on their personal account, that's not considered an official record, right? So is that the current understanding about those emails, that they're not considered official records or discoverable?
Correct. That's exactly what I tell people.
Mm-hmm.
Yeah,
But-
but what do you think about board members having access to all of the association email accounts? When you've got, for a manager, for example, and all of them sort of just being busybodies, so to speak, and looking at information which might be confidential.
Senator, you had something you wanted to say?
Jason?
Yeah, so I think in a light most favorable to unit owners, that under the official record section in this section 15, where it states all other written records of the association not specifically included in the foregoing, which are related to the operation of the association. I think in a light most favorable to the unit owners, that correspondence and exchange should be made available. I can understand almost analogous to like an open investigation situation or an open issue or something that requires some confidentiality or privacy. But anything that has a nexus to things being paid for by association members, at least immediately upon its conclusion, I think should be made available. And as I'm listening to this, I'm like taking notes and, things to edit and all that stuff. That particular section, I would put comma, including correspondence between association members as it relates to unit owners or the operation of the association, to make it clear that, yeah, I do get your emails back and forth about how you guys were nefariously dealing, or fair dealing, what have you. I think they should be available.
That's very interesting. Glad you're taking notes. What about the management company? What happens? We've talked about the board and the prevailing opinion currently, and maybe there's some room for improvement. But what about the management company? So are the emails that are on the manager or the management company's email server, are those also considered official records? And what happens when you have a changeover in management companies? What happens to all those emails after the management company's out?
Well, I've had a problem with that with respect to some associations that I represent, where they have had management changes. And the official email address of the association was always, john@abcmanagement.com. When ABC Management no longer manages the association, those emails become inaccessible, not accessible. Or even if ABC Management changes the designated manager, it's no longer John, it's Jennifer at abcmanagement.com. And they leave, and you've lost all of those emails. I mean, I think, personally, that in this day and age, that association should have a designated email account, which the manager should use as well, or if you're emailing the manager, there should be a CC to the association's email account, so you don't lose all of that information.
So what you're saying essentially is the management company should, to the extent that they are representing the association, they should have an obligation to maintain those emails as official records, and then it's up to somebody else to say, whether it's a judge or the Dbpr or whomever, to say that, hey, that's inaccessible. But should the management company have an obligation to retain and maintain those email and that correspondence as an official record of the association?
Listen, in the days before email, right, many years ago, letters came in and they would keep a a file of letters. You didn't have emails, and that was all part of the official records of the association. The problem with emails is that you lose access. And so there, maybe that's one of the areas of reform, to make sure that that access does not disappear, so to speak. Because
to Bob's point, it might be prudent that in much the way that you have for landlord tenant or a standard sales contract, that you have some uniformity, that any type of management contract for an association makes the emails, the content they're in, and addresses, websites, and URLs the property of the association. Like that should be boilerplate and cannot be contracted out. So you don't have that gap. Otherwise, you basically have a phantom info dump, which is if you lose a management company, you basically have alleviated the certain responsibilities and duties of record retention.
Right, and a lot of associations also have their records maintained off-site, and it may be some of those records may be maintained by management companies. They're, we're all paperless and they're all scanned in, and the management company leaves and doesn't, put all of those records on a jump drive or something and give it to the association, or doesn't email it to them or put them in a Dropbox. And so these associations don't have the access to those as well.
Bob, I have a question. Let's say we open a condo January 1st of 2000. We have a management company in place for 24 months, and then we change management companies, right?
Right.
Does the obligation to retain those records survive the relationship that the management company participated in at one time as a licensed management company in the state of Florida? Do they have to comply if they're not providing them or leaving them with the association? Do they still have to comply even though the relationship is terminated?
Well, I think, in looking at some of the administrative decisions, associations have used as defense as well. The accounting firm has it, or somebody else has it, a third party has the records, and the arbitrators have ruled that that's not a defense. Association records are association records, and the associations have the obligation to maintain them. So there has to be some ability or obligation on the part of the management company, for example, to turn over all of those records. I mean, they do have that obligation anyway, but a lot of them don't, and the associations don't necessarily follow up to obtain their records. So, I would like to see some type of vehicle where, either the association, the management firms have to use an association email address that stays with the association, or there's an automatic, copy. Every time an email comes in or goes out, there's a copy made that goes to the association's email account so that that information can be maintained.
And I would like to add on to that. In 718, there is a requirement for an outgoing board member to turn over association property and official records of the association. Does that exist for managers? I'm not sure that it does in the statute for managers, but that might be something that would be worthwhile to put in. I think it makes sense.
Absolutely. So I hearken to section 468-4334 of the the licensure statute. And so the manager has certain duties, right? And so they have a duty to, with care and full disclosure to the community association, accounting for all funds and not charging unreasonable or excessive fees. So they have some arguable duty in terms of, the accounting and the accounting records, but does that really extend to all correspondence, all information, all documentation? Does it?
I don't know that it's clear.
Right, exactly. So, okay.
But Spencer, can I go back to that question about restricting access to email accounts? Do you think all board members should have access, or do you think there are reasonable rules that can be developed to, prevent that? Because some, I've had complaints, not just with emails, but also with like security, cameras that associations maintain, where board members they've got, a monitor in their units, or it's on their phone, and they seem to want to be, involved in every aspect and monitor everybody's coming and going and things like that. And so you end up having confidential information, or, having invasion of privacy, so to speak. Do you have any comment on that?
Yeah, I see that too. And I don't know really what to tell people when they complain that the board president is watching all the common areas on their cell phone and they feel it's an invasion of privacy. I don't know that there's anything to prohibit that. As far as the email issue, I agree with the senator's point that if you're conducting association business and you're making decisions to which the unit owners are going to be financially responsible, they should be allowed to see those communications. I don't think it's fair that you just have it on a personal email account. So I think that we do need to find a solution for that issue.
Right, but I'm talking about limiting access to the association email account to all board members. If you have 7 board members and you've got a manager and all 7 board members have to log into the association's email and they're looking at all of the applications that come in and the medical records and all of this other information, are you aware of any type of rule to limit that access or any way to limit that access? Or is it just, you have to trust their goodwill and that they're responsible individuals who are not going to.
Yeah, I'm not aware of any rule or restriction on that. Similar to the way that boards often restrict access to speaking with the association's attorney, I think it would be something similar to that that the association would enact upon themselves.
Thank you.
So actually, that was my next hypothetical about surveillance tape. So the question is, if there is surveillance, whether it's on the director's iPad or iPhone, or the security guard has the surveillance video, or there's surveillance video of the common areas, are all of those things official records, or just some of those things official records?
So I'm gonna say I think that that they are official records, but should be used for specific purposes. If there's an incident, something happens, there's an accident, there's a car accident, somebody hits a car, somebody breaks into the building, somebody maybe breaks into a unit, that but the access should be restricted. I mean, not everybody should have the ability just to walk in the office and turn on the DVR, and then watch a day's worth of video. I mean, I think it could be very invasive, but I'm not aware of any regulations on that.
It happens everywhere, right?
Yes.
Cameras everywhere, right? Everywhere. Okay, something to think about. Okay, I recently asked my association for the unit owner roster with any accompanying email addresses and phone numbers. Naturally, what I got back did not include either the email addresses or the telephone numbers. Routinely, the association communicates to the membership by email, and this is the case, especially during COVID.
Well, the statute provides that unit owners, I believe, have to consent in writing to receive official notices by email. And so unless they've consented in writing to receive official notices by email or electronically, then their email addresses are not supposed to be disclosed. But I think that a lot of times associations send informal notices by email, not the official notices, but I don't know, monthly updates, weekly updates, or there was an alarm in the building today, or something happened, or we're having a party, whatever the case may be. And I think there's a distinction between the official notice emails, email addresses, and just general. So I like sticking with if you've given written consent, your email address is accessible. If not, it's not an official record.
So I can't tell you how many times I get this request, because what happens is there's another board election and a unit owner wants to run for the board and says they're pummeling the membership with all these emails, but I don't have those email addresses. How do I get those email addresses? So unless they're inadvertently disclosed, which is what happened in the association where I live, now that everybody has all the email addresses because they were inadvertently, produced to the membership, the unit owners feel that they're in a disadvantage. They want to get those email addresses, but they have no way to get it because of the way the statute reads, correct? No easy way to get those email addresses, right?
I think well, go ahead, I'm sorry. I think it's something that's abused a lot. Those that are installed in the association have free and liberal use of those email addresses all the time and use them for their own reelection purposes and make them scarce or unavailable for others who might want to pierce it into it. But the theory I run under is, if you can go knock on someone's door and that's permissible, you can go knock on a neighbor's door, you can go to a different floor. There are associations now that say there's no campaigning, you can't do this, you can't run in for this. But I believe in the sort of release, but I also believe that we should add another release, which is like, do you want to be contacted for association business only, or, you want to share it? We used to have phone books. Remember those? I mean, literally 30 years ago, you looked in the white pages and you called your neighbors if they didn't answer their door, to get in contact with them. But I think if I can go knock on my neighbor's door physically and engage with that person, and they're basically saying, have access to it, it's fine. It's just, people are, taking advantage of their position, which is what pisses me off the most by far, is taking advantage of their position to gain an upper hand.
Yeah, now,
And they freely and liberally use email addresses for their own personal elections.
and what about knocking on doors and then getting slapped with a violation notice that you've unfairly you've solicited or you've created a nuisance? What happens when you knock on a door and you get smacked over the head by your association?
Well, but I think there's a distinction between, a lot of associations have rules on no solicitation, but campaigning is different than solicitation. And I think I've seen decisions, I'm not positive, that say, it's okay if you want to campaign. In terms of, email addresses, Jason, just going back, in the days of phone books, you could have an unlisted number. I think there is abuse, and I do agree that there is abuse. I represent some associations where there are unit owners who are serial emailers, and they've got the list of all 150 unit owners, and all day long they're sending emails and emails and emails, and my advice to the unit owners who complain is block them. You don't want to get the emails, just block that particular individual. But I agree that there could be an opt-in, opt-out provision where, you're willing to have your email address accessible to everybody, or you just want to limit your email communications to official notices from the association.
Good suggestion. Okay.
But before we move on, I just wanted to add something. I recognize about half the names in this group right now because I've personally spoken to about half the people in here. And I think a lot of these people here have really tough situations with associations that really try to suppress them. And like you said, Commissioner, will slap them with violations or even cease and desist letters from the attorney when they try to campaign or they try to, do something. Even I've heard of people getting cease and desist letters for contacting my office and then circulating a petition for an election monitor. So not all associations are like that in Florida. Most of them are not, and I'm happy to say that. But unfortunately, a lot of the people in this group are dealing with really tough situations.
That's why they're here. We should have a motto: not all associations are created equal, right? Okay. How can I get the bank records? I want to see the front and back of all checks.
Look, I have that in one of the matters that I'm handling now. Some banks in business accounts have copies of the checks, the front and the back. Some don't. I don't know really how you handle that. Certainly, I suppose you can call the bank and say, I need copies of my, the manager can call or the board can call and get copies of checks. But, most banks, I don't think any banks anymore return canceled checks. So it depends on what the banking relationship is and the type of account that they have and whether the association returns it or not. But you can have bank statements and you can have access to the general ledger and to invoices and so forth. I don't know whether anybody else has any comments or thoughts on that.
Okay, we're going to go to the chat in a little bit, but I have a couple more. I'm the property manager and I've only been here for 2 years. One of the unit owners is asking for a set of financial records, but I have none of these. It's not my fault that these records are missing. It happened before I arrived. What should I do? Spencer, you want to talk to this?
There's not much to do, right? If they're not there, they're not there. And I think this is a really unfortunate point. One, it's very hard to prove that someone knowingly destroyed the records. If they did, 718 only provides for a civil penalty. And like I said, it's very hard to prove that records were intentionally destroyed. So unfortunately, if you have a corrupt association out there and they destroy the records, there's really not much you can do. The Dbpr just looks at it and says, what happened to them? Where'd they go? Okay, we take that at face value.
Should
Go
there be stronger, should there be some additional teeth to put the onus on the, again, 468 says that you have an obligation to maintain those records. Who should be responsible? New manager comes in, the old manager destroyed all the records. Who should be responsible for that, right?
In my bill, I sound like Al Gore at the.
We're getting there. We're getting there, Jason. We're getting there
Okay.
soon.
Not Al Gore.
No, but I don't know if you're gonna.
The lockbox, remember that debate? Sorry.
Yeah, but Spencer, I've been dealing with a case for a while where, the association, I think, was formed in the 70s, and for a long time they had all their minute books, and then at some point somebody realized that they're gone. I mean, nobody knows. Could have been one of the former board members, 5 years ago, took them to look at and never gave them back, or one of the management companies, and the attorney on the other side is arguing ceaselessly that they must, if you don't have them, then you must have intentionally destroyed them. You really can't prove that unless you have a witness who saw them do it. And I think the remedy is to instruct the association going forward. You need to be careful about maintenance of your records and keep them under lock and key, whatever, and follow the law. Follow the 718 or 720, which requires that you keep those records. But I've seen sort of abuse on the other side where for whatever reason those records have disappeared. You can't recreate them for the most part.
Yeah, absolutely.
You could go back and get copies of your audits maybe, but unless somebody's got a great memory from 40 years ago, you're not going to recreate minutes.
And here again, okay, that's the case of the missing records. Okay, here's the last typo, and then we're going to get into policy. Website access. We've had condo reforms by way of mandatory website posting requirements, at least for associations that have in excess of 150 units or more. Do we even need official records requests? Is everything now available by website?
No. Not everything, not every official record is required to be on the website. And on top of that, you're only required to have a website if you have 150 units or greater, which is a huge disservice to our condo owners that live in associations with less than 150 units. I often find that it's the associations with less than 150 units that are potentially corrupt, with boards that are stealing money, and they get away with it because it's a smaller association. Maybe they're self-managed. Maybe the majority of the population is elderly. Maybe the majority of the population are foreign investors. But that is accurate from what I see. Is many times it is the smaller associations without as much oversight that are the corrupt ones.
So we don't really have all the requirements for posting. And what about Kaufman? What about the Kaufman language? If, let's say, an association is 150 or over units, but they have, Bob, you can address this about the Kaufman, they don't have Kaufman language. Does that mean that even the larger associations don't have to comply with the official record statute?
I'd have to go back and look at the statute again, but I thought with the website provision applied to all associations of 150 units.
Okay.
Regardless of the declaration, but I'd have to go back and look at it. But I think that if the statute doesn't currently provide that, it should. And I agree with Spencer, and I know Jason has worked on legislation in the past, which would have required almost all associations to have a website. It's not that expensive anymore to create a basic website, and somebody can upload documents on the website so that they're accessible. And the typical association website would have logins for unit owners, so that certain information is not available to people who are not unit owners, for example. And I think that is something, we're in 2021, that there's really no excuse for not having that type of access.
So, but even if we had website access for all, let's say we opened it up and Jason was able to implement some legislative reform to say every association, regardless of size, must have a website. It's still all the information that you would be required under the Condo Act to post on the website. does not necessarily cover what are, you know, the broad-based official records, right? Even if you had full requirement or mandate to have websites, you still would need official records inspections, correct?
Yeah, I think that this is something that could be changed as well. I think that if the association provides the records electronically, I think they should have an out. And I think it's attractive for the unit owners because they don't have to make a request and go in and figure out what time they're going to go and sort through boxes and boxes and boxes and bring their own scanner in even. And then from the association side, they're saving time, they're saving money. They don't have to deal with record requests, which can be a pain in the butt for them. So I think that having it all there is just going to make this entire thing streamlined and painless. And I just think it's so antiquated the way it is now. It really needs to be updated.
Okay,
If I may, Dana, you know, I want to make a comment because I represented a group of owners in a large sort of multi-condominium association, which had a website, and a lot of their documents were on the website, but the labels of the documents were incomprehensible. I mean, you know, there's got to be some organized way, you know, minutes or contract with ABC Electric or whatever. I mean, this was, you had to open up every document to try to figure out what it was. So there needs to be rules also about organizing and proper disclosure and proper labeling so that unit owners have easy access to the websites and can understand, you know, there's a section for contracts and a section for minutes and documents and bids and so forth, so that, you know, it's appropriate access, it's good access.
okay, Jason, now the floor is yours. Now we're going to get into.
No, I don't want the floor, but the website for me is, and I'm like thinking of Mayor Wiseman, you know, whispering in my ear when we talk about these things. It's not a big deal. This is not a big deal. And it's the truth. How many of you use Amazon.com? Okay. You're not making any physical inspection, purchase anything. You're doing it on your phone or your laptop or your desktop, and it gets delivered to your door. And it's wildly efficient and it works. So here's my point. The second question I asked Secretary Beshears a year ago was, listen, some associations are going to say, we're only 10 units, we're only 25 units. We're not the big, expensive, fancy places, okay? And I said, Secretary Beshears, when we have this town hall, I need you to call that bluff if somebody complains about it. And I need you to offer to host that website. So you can go with the a la carte plan, and most management companies are going to find a way to like host this anyway, or the association is going to do it on their own, you know, server or space or outsource third provider. But I didn't want anyone to complain that there was a cost barrier, that it was cost prohibitive to do it. So I said, would DBPR be willing and able and amenable to hosting an association's website? And he said, absolutely. So there's no excuse. Okay, that's number one. The filing thing is absolutely true. I always think of The Firm. Remember with Tom Cruise when they try to bury him in his first case and they go, here's discovery, and you open up like a boardroom filled with 150 boxes and he's looking for one piece of paper. So the point is, yes, there's a reasonable amount, but it does exactly what Spencer and Bob says, which is the following. I get phone calls from a lot of you guys because the manager is just being nasty to you, or you're being nasty to the manager. We get phone calls from management companies too, okay? And that acrimonious relation, how wonderful it is, and I use Amazon, that you can be in your bathrobe, okay, drinking peppermint tea at 3 a.m. because you're sleepless and you'd like to go through the records. Like you're bored and you want to go through the records of the place that you live in. That's wonderful. Forget this crap about 45 miles. You got to wait till they're ready. We're going to open the door. I'm not going to show. That's crap, okay? They should be absolutely available. It's 2021. We should click our way right to this information. We should live in an area of sunshine, figuratively and literally, and make all of these things available. The beauty of this, as a former prosecutor, is it's per se your duty. Then it creates a presumption that if it's not there, the records are not there, some funny business is going on. And that's a great position to be in. There are always more unit owners than there are association members or board members or managers, okay? So the rights of the many, of the majority, is to have open and free and unfettered access to those records. Now, the only thing that stings is the initial period of scanning these things and properly putting them in folders. That stinks. But I can assure you that 1 week that it takes will save hundreds and hundreds of man hours every year of having to field and accommodate and make appointments for and concessions and accommodations to show people the records, which are not efficient anyway. That's a no-brainer. I know that we have some groups that think my bill is a chilling effect on volunteerism, but I've known some pretty professional people that take it on because this is your greatest asset. This is your future. So nobody can convince me otherwise that it just doesn't make sense from every single condo association to do so. That's it.
Okay, so.
I want to jump in there 1 second because
Go ahead.
I definitely agree with you because I have association clients where either the manager or a board member is literally got a full-time job responding to record requests. And why should they have to do that? And why should you be paying your manager to do that? Or why should a board member, if you're self-managed, have to do that when everything can be on the website and you don't have to deal with all of that nonsense? So that's a great suggestion. Everybody has a website.
So, okay, so now so I think, okay, we're all in agreement. We should have greater accessibility through website and through the internet and electronic records. The voting records, the electronic voting legislation that happened more recently, how quickly though are associations to really adapt to it? Like what percentage of associations do electronic voting? And if they don't do even electronic voting, how are you going to get them to put up their websites? Like is the pushback all about money, or is the pushback about, hey, I just don't have the resources, I can't do it? Well, what's the great challenge? What's the great impediment? Is it just slow to adapt to an electronic age, or what do you think, Jason? What's the problem here?
Well, the only other thing that's a worse system set up to sort of eat itself would be like the criminal justice system, where we have defendants pay for all court costs and fees and fines and everything like that. And that low collection rate is supposed to go ahead and fund all of the operations for public safety. The second worst is condo associations. So if the Lepsetters ever finally prevail, and they should, otherwise I may go down there with a guy named Tony, who has no last name. It's the worst kind of abuse, because the wrongdoing of those people that you voted in, you end up paying for it. On a small scale and a large scale, Mayor Wiseman will tell you a story, unrelated but kind of analogous. A few homeowners gave a developer a really hard time about something, and now everybody's slapped with a special assessment to pay for the actions of a few. So they are playing with house money. They're playing with your money. And then you end up having to pay for it. Or on the alternative, which is even more punitive, you live in a 72 unit building in the Boca area with a $500+ a month association fee, and you get slapped with a $222,000 legal bill from a large law firm, beginning with B and the other one is P. I mean, come on.
No names.
It shocks the conscience. It should shock your conscience. It should root at your core. It should shake your core about how inequitable it is. And the dispute arises, the genesis of some of these disputes are like $400. We've seen ones that are $800. Balloon up into, the prevailing party getting, the one thing Spencer has to admit is he probably thought I was using hyperbole or exaggerating for effect when I started throwing out some of the numbers and the amounts of legal fees attached to these cases. Be honest, Spencer, didn't you? And then when you looked into it, you're like, my God, some of these are like 6 months worth of the entire association fee for the condominium is the amount of dispute in question. It's crazy. Yeah. And it's inequitable. And it doesn't happen anywhere else. Okay. Courts of competent jurisdiction, Dana, you know this, Bob knows this, circuit courts, it would shake them at their core to see the amount of in dispute might be $460 or being off by a day on your official records request and suing. And then all of a sudden you're slapped with a $75,000 to $150,000 legal bill. I mean, this is nuts.
There was a case that went through all the reptiles, and Bob, you know about this case as well, that everybody got. It was kind of a cautionary tale. The judge really admonished. It was an HOA where it was a landscaping dispute for what, $2,000 or $4,000, and then it ended up being a $200,000 prevailing party attorney's fees for a $4,000. I mean, think about the equity of that. $200,000 in legal fees for a $4,000 landscaping issue. That's really what it was. So let's talk about what's in your proposed legislation. How does this dovetail into official records, and why are you getting pushback, or what are some of the challenges, Senator Pizzo, that you're facing with this particular reform, and why?
I think some of the particular challenges are some of the law firms that are involved in this business donate heavily to people's campaigns. For good or bad, most of you watching who are my constituents are stuck with somebody who can't be influenced by a check. I got to follow my heart, and I'm a dog with a bone. I mean, that's just the bottom line. So when we first proposed this bill, you know this is sort of a rhetorical question. The largest law firm in this space sent out an email to like 12,000 association managers and interested parties saying that I'm looking to lock everybody up, and it's going to have a chilling effect, and it's detrimental. And then, my retort is the law-abiding, well-intended person has nothing to fear ever.
Well,
I mean,
tell us a
in
little.
that position.
Tell us a little bit about this bill. So we had there was some legislation that was circulated amongst the condo attorneys, the reptiles, and it talked.
Yeah, listen, Marco Rubio, came out with a big proposal about this many years ago. Okay, many years ago. I think I saw Lydia nodding her head. I think she knows what I'm doing. Many years ago, Marco Rubio came out with something. But what really triggered for me is I had just finished at the state attorney's office. And there was a final report of the Miami-Dade County grand jury that came out exposing all kinds of problems, all kinds of issues. So it became like a menu, to pick from. What issues are, most relevant or most prevalent. And listen, it's universal in the sense that it extends to Broward and Palm Beach County and other areas that, that have these issues. And then it was just kind of like I wanted to not shift the burden, but I wanted to be fair in a sense that, like, now that things are economical, that they're not cost prohibitive like we talked about with the website, things are not difficult anymore. Storage is not an issue. People are accessible and global and all that stuff. That some of this is a no-brainer. But then I also wanted to really address the gray areas. And here's what I mean by the gray areas. I see Christine's on here, so her place is a perfect example. Okay.
Oh,
I'm so sick and tired of finding out ad nauseum now that the GC hired to do the lobby, mysteriously the same tile and renovation's been done in the association members unit. It's getting so tired. The problem is the way it's written, and back and forth with John. We included John Pericles from the state attorney's office, who really feels very sympathetic for. I mean, I see another person on here. She probably doesn't want me to call her out, but I know that her association manager uses the association Amex to buy Victoria's Secrets for his girlfriend. Please tell me what the nexus is between Victoria's Secrets on the Association American Express card, okay, and anything going in the lobby. Do people cheat and buy $2,000 worth of flowers and bring half of them home or resell? Yes, but that's easier to get away with. You try explaining Victoria's Secrets to anybody and how that has to do with association business. But the gray area is the following. I can, under the current law, if I get a contract for $1.5 million to redo your lobby, okay, and I want to thank you with a Rolex or redoing your kitchen, that's not illegal. The only time it's illegal is if the actual contract is $1.2 million and I puff it up to $1.3 million to pay for your present gift or whatever it is. Good luck proving that. Okay, it's the bottom line. Other shady stuff. When we have to intervene, and Mayor Wiseman knows this, I kind of get her blessing before I do something, because very often if it happens within the four corners of her city, sometimes I got to call a board president and be like, stop the shadiness, okay? I know the people that got ballots, and I know the people that didn't get ballots. I want the ballots delivered to everybody by tomorrow. Give me the time so I can hold you to it. Like, I have to do those things. We shouldn't have to. There's 4.5 million condominium doors in the state of Florida. And at one time, Spencer will tell you, there was only 38 inspectors for 4.5 million condos. And how unfair, we kept, and this is one of the things that we have to press on, and we could use everybody's support. You guys pay your $4 per unit, that gets rated every year and put in for something else to go pay for something else. year, for some other pork on something else somewhere else, like the Sadowski Affordable Housing Fund, which gets rated every year for something else less noble. And that's one of the things that we have to insist upon, is that the money you're paying, how many of you know that that part of what you pay every year goes to the Department of Banking and Professional Regulation?
Part of it.
Okay. And do you know that it gets rated most of it gets rated every year and not used for its intended purpose? No. Enid knows that. Okay. So the website's a big thing, it's rebuttal presumption. And I do actually seek, instead of what Spencer said before, were some civil penalties or civil issues, I am seeking to criminalize bad actors. If you are committing intentional acts to defraud, to hide, to escape. So it starts with the presumption, everything goes up online or everything's easily accessible. And then if you're found to have not made it available because you were hiding, you're getting in trouble. We want to define this. Remember, the association members are not public officials in the sense that they have, they have a general obligation, ethical and moral obligation, fiduciary obligation, but not one that's subject to criminal penalty if they grossly violate it, or what you would think would be gross violations of it. So that's an important issue. I'm also really looking to, and I don't think it's going to have a chilling effect. Like Mayor Wiseman's husband, Steve, has served on the board. And it's like when people talk about term limits, there's some people that you can't wait till they get out of office. And then there's some people that's like, God, I hope that guy never goes away, because I wouldn't want to do what he does and put in the hours. I won't do it. But that's, one particular issue.
About the official records, you got some pushback from the condo lawyers about the official records part, and isn't that related to some sort of a manager certification or affidavit?
So under the I think it's the 463 statute that you mentioned before, right? For managers, the reason why I posed the question about does the obligation survive the relationship, I think if you're duly licensed and CAM in the state of Florida, I think whether or not your relationship happens to extend, let's say for the full 7 years, I think it is incumbent upon you, if you maintain your licensure, that you should also maintain the records, even if you no longer have a relationship. And the reason being is it's not an onerous, overwhelming task. It doesn't create an economic hardship. But if you did business for a period of time with XYZ condominium, and you still remain a licensed, property manager in the state of Florida, I think you should retain those records. A lot of professions have to, okay? I forget what it is for like medical stuff, but I've changed dentists in my lifetime, and for some period of time, they kept my records. They would transfer me, if necessary. A lot of places. Listen, I don't care how old you are. If you give me a week, I can get your school transcripts. I'm being serious. I can get your school transcripts. It might be a microfiche for a couple of you, but I can get them. So why the hell is it so hard to find something from 3 years ago on a management company you fired, dealing with millions of dollars a year?
Well,
the excuses are, and this is the first question you asked me. There are some people who make a very good living on selling fear, on selling how complicated something is, that only they can do it and they're professionals at it, okay? It's how people win elections. It's how people get hired. It's how people keep their spots. They create the illusion that things are so complicated that you need a professional at it and you'll pay a premium for it. It's really not. It's really not. And there's a lot of people who are in anticipation of stuff like this, not happy with me and don't like that I'm around. I'm okay with that.
Jason, when will we see the bill?
It'll be posted on, I had to do a little charming and convincing for one of the leadership people in the Senate, Kathleen Pasadomo. She's a senator. She's now the majority leader. She'll be the next Senate president, and she's on board. I mean, she knows something's got to happen. Sometimes there's a little pride of authorship. I reach across the aisle, I think, pretty well, but there's sometimes some pride of authorship that they would prefer maybe, a particular party do something. And again, I've even offered, Senator Baxley has a condo bill as well. I'd be happy to slap everything onto his. And also, Secretary Beshears was very helpful in kind of like telling everyone to calm down. I know he's a freshman Democrat, but he's in the mix of it and he's reasonable and he understands, the legalese of it. So the position that we're in is, I think we have the full force and effect, the blessing of DBPR to do something, which by extension is, serves at the pleasure of the governor as an appointee. And the other side, also agrees. I wasn't joking when I said Senator Brandis calls some association members sleeper cells of Al-Qaeda.
Okay, we're looking forward to the bill. Spencer, I want to get to you for a couple seconds, and then I want to go to the chat because we have so many messages here and they keep rolling in, and I haven't been able to address them because we've been kind of engrossed in this conversation. Just a couple of quick questions for you, Spencer. My association flat out refused to produce the bank statements. Even worse, some of the backup pertaining to their general contractor that they just hired. Can the association or the manager be held criminally liable for their failure to produce?
Criminally liable, probably not under current laws. There's very few situations where you can go after these people individually and criminally.
What about, what's the difference between filing a complaint with the DBPR and filing an arbitration action? How does that work? And Bob, feel free to join in after Spencer.
Sure. So a complaint with the Division of Condos, Timeshares, and Mobile Homes is just that. You're filing a complaint, whether that's a financial issue on behalf of the association or election misconduct or a failure to provide records after you've made a request. They then assign an investigator, they'll look at it, and then they can sanction the association. Unfortunately, that means that you're going to be partially responsible for that payment. Now, on the other hand, arbitration is different. Arbitration is like a mini court case where it's you against the association. And there's a whole procedure there. It was designed to prevent things from going to litigation and to keep the costs way lower than they would be had they went to litigation. Unfortunately, it doesn't always work like that. It's probably not a perfect system. And what I see is if the association loses in arbitration, the ones that want to keep fighting can just file, basically appeal it to actual court. So it's certainly not a perfect system with arbitration, and I have my own ideas, and I'm looking forward to being involved and hopefully bringing some positive changes to the division with the arbitration.
Okay, great response. Bob, complaint or arbitrate?
It really depends on the circumstances. I mean, sometimes it's more expeditious, easier, more cost effective to make a complaint. I have on behalf of some clients who have requested records from associations. We sent it by certified mail. We don't get it within the 10 business days, wait a little longer, and then file a complaint with the Bureau of Compliance and send them a copy of the request, along with a copy of the green card to prove that it was received. The local investigator, there's an office in Miami-Dade County and Doral, there's an office in Broward County. They'll contact the unit owner or the attorney and whatnot, and advise that they received the complaint and they're going to investigate and reach out to the association and ask for a response. So, I mean, sometimes they're doing it withholding intentionally, sometimes they're not. I think the division used to be more inclined to educate and don't do it again. I think they're finding more. Spencer, maybe you could address that than they used to in the past. But sometimes getting those letters from the division, cures the problem, or at least gets the boards and managers to do what they're supposed to do. And those letters and the findings that you receive from the division are become official records of the association, which have to be maintained.
Okay, so it's really the first line of offense is really to file that complaint. You don't get those records in 10 days, you don't go into arbitration. You're basically going to file a complaint and see, and the DBPR is going to jump on that, right away.
Well, I mean, they generally do. I mean, it's really just sort of a decision you make. You're going to go the administrative route, by filing the complaint, or do you want to send your pre-arbitration notice and give them time to comply? And then if they don't, then you file your arbitration petition that could go on for months and months and months and months.
Is there any?
It's not supposed to, but it does.
Is there any reason why you would want to file an arbitration action straight up rather than file a complaint?
I think maybe if there's been serial abuse, you've made 5, 6, 7 requests, then maybe you would do that. I'm not sure. Spencer, what do you think?
Yeah, well, I think there are certain situations where you would not be eligible to file a complaint that it would be necessary to go to arbitration. Like if you're challenging the association for making an alteration, which you believe was a
Right.
material alteration, right? That you can't make a complaint about that.
Right, that's
but-
correct.
Yeah.
Right. Because as you indicated, I mean, there are three areas. It's financial issues, election issues,
Elections and record requests.
and record requests where you can file, go to the Bureau of Compliance or the division, but anything else, you'd have to do arbitration.
So it's kind of hybrid. You're saying, oh, there's an alteration, and by the way, they didn't give us all the bids, or they didn't give us all the records, and you would kind
Yeah,
of.
it's like the compliance will enforce the law, and they're investigators, right? They're not judges. They're not going to look at your legal argument and say, okay, you're right, you're wrong. Whose interpretation of the documents is correct? That's not what the Bureau of Compliance does. So when you get into that gray area of the law, now we're hearing arguments on both sides, and especially when we're interpreting governing documents, that's not something the Bureau of Compliance is going to do. That has to go to arbitration, which is essentially a mini court case.
Okay, all right. Who issues subpoenas? Last question. Who issues subpoenas, and how does the subpoena power work? And under what circumstances are subpoenas issued?
Hopefully I will soon if I and Senator Pizzo have our way. But for now, it is with the division, and I believe it's somewhere in 718. It might be 501. And what it says is if you've made 2 record requests and the 10 days elapsed on the first one for them to provide the records, then you made a second one and the 10 days elapsed on that one, then you can file the complaint to the division, and the division at that point will subpoena the records. I'm working with the division, and we are creating the infrastructure such that I can recommend the division to subpoena records, and it doesn't have to go through the division in the same way that it has done before. So, like I work with, like I said, half the people in this group approximately. And I don't think that any ombudsman prior to me has had that sort of relationship with the division where they're recommending enforcement action, recommending subpoenas. So I'm excited to have that sort of relationship.
I think that's really wonderful. So it's really the division has the authority to issue a subpoena. It's not like I could just go into court and say, hey, I need those records. I'm going to go to the judge. I have to go to you guys, and then you're the one who issues the subpoena, right?
Yeah.
The division, the Dbpr. Wonderful.
Can I have a question? So, so you're a unit owner, you make your records request, and the association provides you with, the records to review, and you decide you want copies. What's a reasonable copying cost if the association is doing it itself? And can they charge you for the time that they spend making the copies and organizing the records for you?
I believe they can. I believe there's arbitration cases on that. I believe they can. And I believe, I'm trying to remember the amount of cents per page. If either of you
I mean, I've seen 25 cents, 50 cents,
Yeah, I think like 50 cents is what I saw. 50 cents per page is what I saw, I think.
That's absolutely correct. Okay, now it's time for chat. First and foremost, Pizzo, next Florida governor. Woohoo! Senator Pizzo, you got a lot of condo supporters here in the, when it comes to condo, you got a lot.
Hold on, I have one more special treat for a number of you.
Who's anybody join?
Hold on. One more
Maggie.
special treat. One more special treat.
Somebody's joining. We got
Popping in. It's Maggie.
Hey, Maggie. Maggie. Maggie's in the house. Maggie. Nice.
Maggie's there.
Maggie, nice.
So,
All right, thank you, Maggie.
Listen, just
She's
to,
the hero.
yeah, go ahead.
She's the hero. She's the unsung hero, right?
Yeah.
Okay. Senator Pizzo, thank you for joining us, and thank you for your service to our community.
Let's get to the questions.
Okay, Spencer, you're going above and beyond what anybody's done before. Maggie is the best. Let's see, sorry guys, I got so many. Okay, we want to wrap this up pretty soon. Lack of transparency. Are you going to address a collusion between property managers and the board?
Yes.
Okay.
Yes.
Okay, should all official records be in the website for condos with more than 150 units? We've talked about that, which makes the associations with less than 100 more vulnerable. We've talked about that. Financial statements for our condo are always 2 months late. Is this reasonable for a self-managed condo of 177 units?
2 months late in a what? I'm sorry?
The financial statements.
Yeah, no, that's way too long. Listen, guys, don't forget about the fact that, get a hold of me, send me an email, and I can call, and the worst that they can say is what the prettiest girl in high school told me when I asked her to the prom, because she was a senior and I was a freshman, is no. You know what I mean? And then we can find something else.
Okay,
She
you have the
said,
right.
she said yes eventually, but initially she said no.
Okay, I thought emails could only be shared if it's a quorum of board members. Senator, do it, write it up for March. Owners are at a disadvantage if they don't have access to email addresses, promoting somebody for the seat on the board. If bylaws require all records to be in the building office, is there a statute or law that overrides that and allows records to be kept in the manager's office?
That I don't know of. It's just about reasonable retention. And the other thing is, and I think of Steve Wiseman when I think of this as well. New people coming in need training. Like, they need to understand. And typically ignorance of a law that's criminal is never an excuse. Like, just because you didn't know what you're exposed, that it was a second-degree felony, what you committed doesn't ever excuse anything. But lately, and as everybody understands, I think you guys just get a form and you sign off, and to say that you've actually reviewed it. Things like throwing in, like, under no circumstances whatsoever should you be emailing any member, any unit owner, whatever, about campaigning or about anything. The problem is that a guy like Steve Wiseman, if he's on his board in Aventura, might be like, hey, did you see the Yankees game last night? I mean, when does it cross the line or constitute that kind of behavior? So you need more of an all or nothing kind of situation. If you're using that for access, everybody needs to be able to do the same thing.
Just by way of background, there's a nice little Dbpr pamphlet on official records. If anybody's interested, Spencer, you can circulate, or I can, but I think they put together a nice little pamphlet on official records of condominium associations, what you have, what you don't have, and it's obviously available on the website. Who should own the website for condos with more than 150 units, the association or the property management company? I do not understand the language of 718.111.
Yeah, 1111. It runs with the condo. It runs with the building. So if we all get wiped out by COVID and someone else moves in, it runs with the building. It stays, however storage is kept, hopefully electronically and digitally going forward. My feeling is it runs with the building.
Okay.
So who owns it? That was the question before. The management company takes off, like, listen, we're going to set you up with a platinum package. We're going to build you a website. We're going to host it. We're going to set up email addresses. And then you fire them the following year and they take everything with them. That's not cool. It's got to run with the building.
I think that's right. I think that's absolutely right. Do you agree? Everybody agree? Nod. Okay. Who should own the website for condos with more than 100? We talked about that. Let's go on to the next. I agree, it's a privacy issue. I asked my board to send an email to owners to voluntary opt-in with an email list so we could communicate with others, but they refused. My board, they don't want to be organized. They've been in power for 14 years, no intention to leave. Agree, access about emails. Our treasurer fixed all cameras and has full control of videos.
We have a lot of those situations. We also have people that are getting very close to a violation of a felony violation of 930, Florida Statute 934. Not non-consensual recording of other individuals. We have some board members who send security guards basically to go film families doing things. At its core, the United States Supreme Court said, basically said, do you have an expectation of privacy? And is that expectation one that society is prepared to recognize? And while you may have access to certain areas where those cameras are, and they in and themselves are not per se private because you have open access to in a common area, it starts to borderline on creepy and predatory and like nefarious voyeurism at some point. There are people who delight in having that kind of access and make you think that Big Brother is watching. So to Spencer's earlier point, and I think Bob also echoed the point about whether or not that the review of those recordings are meant to be based on an accident or needed for some sort of investigation, whose dog really peed on the carpet, things like that.
It's funny you say that because I've been fielding requests about drones and things like that. And actually I'm piloting a condo rights workshop on privacy rights in the next couple of months. So I'm looking forward to putting that together. Jason, I'd love for you to be, if you're interested in serving on that panel, whomever, but I think privacy rights are definitely, I think it's an emerging area in condo living. So we'll be talking about that hopefully in a couple of months. Okay.
Another thing, Dana, about cameras. I mean, if a building doesn't have cameras and they want to install cameras, unless there's a security need, there's been criminal activity and so forth, it's a material alteration of the common elements to install those cameras and security systems all over the place, and the unit owners have the right to vote on that. Unless you can demonstrate that there's been specific criminal activity in that area or in the building, and you're doing it for security reasons.
I think that's absolutely right. If anybody has any comments on that, I see Enid nodding her head. Absentee owners, what if there was a stalker living in the building? It's not the same as technology has changed. Renters, can association directors approve a project without consulting first with the owners? I think that answer, Bob, is pretty. What do you think?
I'm sorry, what was that, Dana?
Can directors approve, a project without consulting first with the owners?
Well, I mean, all contracts have to be approved at a board meeting, which is duly noticed. And at those board meetings, all unit owners have the right to speak and comment. If the contract is to change something in the building, again, if it's a material alteration, then that would have to be put to the vote of the unit owners in most associations. So it depends on the nature, but I advise all my association clients, don't do anything of any substance that's, without doing it at a board meeting that's been noticed, so that unit owners have the opportunity to participate.
We're running.
Sometimes there's an exception, and this actually happens with cities and schools as well. As you guys know, over the past couple of years, we've had a couple scares at schools and stuff like that. I do believe in limited exception if there's like a health, life, and safety issue, but it has to be emergent and imminent, right. And then it basically expires. I mean,
or it can be ratified later on if it's
right. However, I'm inclined. Some people are uncomfortable, and I know a lot of you are told no. I'm inclined to allow people to record and make the rebuttable presumption that it's an open meeting, and that there is no, I don't believe in expectation of privacy as it relates to a condo board association meeting, but I know plenty of people who have been told, don't you dare, and they're doing it like on the sly, like in their pocket, recording something.
But the statute provides that if you have the right to videotape meetings, but if you give notice that you're going to do it, and you have to be stationary, you can't be walking around.
Right, but
you have the right to tape record them as well. So.
You have the right to videotape, but this has come up and been discussed at prior workshops. You don't have the right to put it on YouTube, right?
Right. If there's a closed Facebook group for ABC Oceanside Condominium, you may be able to post it on that closed group, but you're right, not on YouTube or not to the general public.
And it's also the expectation of people that are participating that it won't be blasted. But we have condos right now in Miami who, if you say a disparaging word about one of the association members, it's in their rules. They will fine you. Spencer's not shaking his head in disbelief, but he knows it's true.
I've seen that as well.
They will fine you $100 as a unit owner if you say something mean about one of the condo board members on Facebook. That's actually in the rules. Folks, this is the intention of all of this. You have criminal prosecution state attorney's office over here for a clear and beyond a reasonable doubt that something's wrong here, probable cause at the very least. You have Spencer over here who's trying to be a sweet, nice gentleman, and what I'm trying to do is just make sure that they meet and there's no large gap in between. So if something needs to be referred or something like rises to the level and goes past his threshold, past his purview, or vice versa, they refer to him. Conversely, prosecutors right now don't have a Spencer to give stuff to say this doesn't rise to the level of a felony, but it's certainly unethical. It's certainly actionable by your agency. And there has never been that connection for forever, really. And that's what we're trying to foster.
Okay.
He's like Elliot Ness Jr. Light, diet Ness.
Diet Ness. Okay, so we got a lot of other chats. I know we're running very long on this presentation, and so that just goes to show you how engaging this topic is. We're getting a lot on the chats about term limits. I think we've kind of gone through that issue. I think everybody, at this point accepts, or at least may not accept, but acknowledges, the Division of Condominium's position that the term limits is not a retroactively applied statute, and that those term limits do not start or vest until 2024. Is that the prevailing opinion about that? Everett, Spencer, Bob, Jason, we're all nodding our heads about that, right?
I think the law.
I know there's some people that feel very, 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 very certain and firm about that idea, and they want it to be retroactive. I would almost be inclined to, I know this is not going to make everybody happy, but what happens in the sense that like nobody else wants to run?
Well, yeah, but there was the exception. I think if nobody else wants to run, then you
Or-
can.
What
Or if
about
you
a
get certain
90
percentage?
What about what's the percentage? Is it a supermajority can
Like
override?
2/3 or something. If you get 2/3 of the vote, I think it.
Yeah,
And
so
it's
66%.
26, not 24, Commissioner Goldman.
Right.
2026, it's 20, oh, it's that far out. So it doesn't toll from the 2017.
No, it was 2018 that the law became effective, and so.
Because I think it was amended once, and then, so it's 2026, okay. Okay, last couple, my condo association doesn't provide statement of my account. Is this legal? They like to tag on the charges to disqualify prospect candidates who want to run for the board. Isn't that the idea? If you're 1 penny off, you can be disqualified?
Yes, absolutely. I see this every day.
Right.
So can
And you
I,
got to file a complaint with the division.
right.
Sorry.
So can I interject best practice? The best practice being, if you want to run for the board, get into that office and make sure that you're up to the penny, because 1 penny can disqualify you, correct?
And yes, and it's the 40th day before the election. You
Right.
need to be in the office that day and make sure.
So,
Right, exactly. I tell my clients the same thing, or, board members who want to run, as Spencer said, get your statement on that day, on the 40th day.
the 40th day, get the statement, best practice, because you can get knocked out of the box for very little, and it happens routinely and it happens consistently, right? Okay. 11 messages, condo rights. What if they fall out of good standing? Okay. So thank you for organizing. Thank you very much. Condo corruption dictatorship. I think we've kind of covered the gamut for official records inspections, and we've tacked on a few additional topics, but certainly Jason, Spencer, if you have all your information, if anybody's interested in this little pamphlet on official records inspections, please direct message. Jason, you have all your information. You're always very accessible, you and Maggie. Spencer, you're just doing a yeoman's job, really out there for the residents, really out there for the community. A great congratulations. You've really, you just knocked it out of the park right away. It's really, you're really a gift, really you're just a great different, just great part of this conversation, and hopefully we'll get some reform initiatives together. And then Bob Yaffe, of course, my partner in crime. Always a great pleasure to serve on these panels with you. You just add so much in terms of your knowledge, your expertise, and your just practical information and wisdom about these topics. So I want to just give Senator Pizzo just a final word on. Can I unmute you? Just can you give us a final word before we?
Sure. I appreciate everyone's support. What I don't want to do, what's happened in years past, is cheerlead. You're here because you're engaged, because we're all on this issue together, or these numbers of issues together. I will be selfishly for the support of the bill, both in the House and the Senate, maybe asking you to do some direct calling and or emails and urging, but keep them unique, keep them simple, just, sort of express the situation, and I appreciate it. Things can be amended. I know Christina asked the same question. We're gonna be trying to get some final words from Spencer. We'll have several weeks to go ahead and make additions and amendments on things and get this through, but I appreciate everybody. I am accessible, but so are you guys, and you're engaged, so I appreciate it.
Terrific, wonderful. Spencer, any other comments? Bob, any other? I think we've pretty much covered some of the.
Yeah,
Yes.
I wanted to bring up the topic that former Representative Julio Robina brought up on the last one, which was the condo law task force. What I have found is that it has been at times difficult to get buy-in from the police, and either they're not interested in condo issues or they don't have the resources for it, whatever the reason is. I feel that if we were to have this task force that would be dedicated to condo issues, that it would be one of the most beneficial things that we could do for condo owners in the state.
Well, let's just have another workshop about it fairly rapidly. How does that sound?
Yeah, absolutely.
Okay,
Very good.
wonderful. Well, thank you again, everybody. I see a lot of familiar faces. Thank you so much to our esteemed panel. Wonderful condo rights workshop. Let's just keep rolling along, and let's see some real reform happen in our condo laws. Thank you so much.
Thank you, Dana. Thank you,
Thank
Jason.
you, everyone.
Thank you. Thank
Good night.
you, everybody.
Thank you, everyone.
Thank you.
Good night.
Thanks,
you.
everyone.
Thank you, everyone. Bye.
Bye.
When this happened.